Welcome back to the second of our Legal Tuesdays, our series looking at key legal issues arising in the film and television industries. So in this, the second of three sessions covering the topic of copyright, I want to talk a bit about moral rights, including what they are and who holds them. And I also want to look at some of the issues arising in collaboration scenarios and some of the pitfalls to be aware of when you are collaborating on a project. So what are moral rights? Well, moral rights are one of the three principal forms of rights offered by copyright, the other two being the proprietary or economic rights in the work and the artist's right to a royalty on resale of the work. Moral rights were only fully recognised as a matter of English law in 1989 when the CDPA came into force. By that time, they were already well established in other European jurisdictions. Moral rights give the author of the work, so often the principal director of a film or production, some control over how the work is exploited in the future, regardless of what has happened to the ownership of the copyright. Moral rights recognise, in a legally enforceable way, that the author of a work retains some link or bond with the work in question, regardless of hard economic considerations. Who holds the moral rights in a work? Well, the author of the work, or the film director, will hold the moral rights and will retain the right, as such, to be identified as the author or the director, and crucially, to object to any derogatory treatment of the work in question, regardless of what has happened to the ownership of the copyright in the meantime. So moral rights are distinct from the economic rights in a work, which means that it's very important to maintain a distinction between the holder of the moral right and the holder of the copyright that subsists in the work in question. They may not always be the same party. The key point to remember is that moral rights will stay with the author regardless of what has happened to the ownership of the copyright in that work. Let's look at collaboration and joint authorship. Now, the significance of joint authorship is that if it applies, the joint authors will jointly own the copyright in the work. The test for joint authorship is where two or more authors collaborate to produce a work where the contribution of each author is not distinct from that of the other authors. Note that under the CDPA, a film will be considered a work of joint authorship unless the principal director and the producer are the same person. A party will only be a joint author of a work and therefore a joint owner of the copyright if he or she, or in the case of a company, the employees, collaborated in the creation of the work. Collaboration must be by way of a common design, which is to say that the parties must have engaged in cooperative acts at the time the work came into existence and which led to its creation. Each of those acts must be sufficient to qualify the party for joint authorship, which is to say that the parties must have contributed a significant amount of the skill and labour protected by copyright. In general, in a joint authorship scenario, each joint author has the same protections and rights as a sole author would, which means that a joint author can still sue another joint author who engages in any of the prohibited acts protected by copyright without permission. Now, as with other types of copyright, jointly owned copyright can be transferred, which means that it's entirely possible for a jointly authored work to be owned by a single party, provided an appropriate assignment has taken place. And finally for today, let me talk briefly about idea theft and implied contracts. So remember here that copyright will only protect the expression of an idea. It will not protect an idea itself, regardless of how terrific or well developed the idea is. So the top tip here is commit your idea to paper or to computer as soon as possible, whether that's in the form of a Bible, a treatment, or something similar. Now, even if copyright protection is not available, but you think someone may have stolen your idea, you should consider an implied contract argument, which is based on the theory that if you pitched your idea to a studio or a production company, there was an implied contract that if they used that idea, you would get credit. So that's it for today's Legal Tuesdays. Please do join us next time when we'll continue our look at copyright. See you then.